Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome to another episode of Life's Third Act. This is part 2 of our discussion of how a trust works, using the Michael Jackson trust situation as a sort of canvas for us to demonstrate or illustrate some of the concepts that we teach our clients at Cordell & Cordell when we're doing their estate planning. So part 1, we talked about the role of the trust. We gave a little bit of history about the trust of Michael Jackson. In this show, again, our goal is not to talk about the life of Michael Jackson. Again, that's been done many places, and they've done a much better job than we could do. Our focus is to talk about the estate, his planning, and what has happened subsequently, and what kernels of knowledge can we extract from that about how we and you can better plan for your loved ones. So that's kind of our approach. We talked about the size of the estate. We talked about the appointment of the trustees, which were 2 professionals in the music field, in the performance field, recording. These were people who had participated in Michael Jackson's success, and he trusted them, so he chose these 2 individuals who were not family members. We talked about the fact that the estate at the time of his death was literally negative in value, and very shortly thereafter, due in large part, not entirely, to good management decisions on the part of these trustees, it went to a value of $600 million plus, with a couple billion dollars in revenues being generated. So this was a massive turnaround, and it occurred in relatively short order in the first 5, 6, 7 or so years, and has since grown, of course. But this decision regarding these trustees has turned out, by all appearances, from a financial standpoint, to be wonderful. And yet, we know from recent news reports that there's been some conflict with the family, and there's some dissatisfaction on the part of beneficiaries and trustees. Well, we talked about in our first episode how important it is to choose the right trustees, in part to better deal with beneficiaries, to try to avoid conflicts of interest, to anticipate that there may be some disagreements about how much should be paid out and when. So the trustee selection should be one where you consider the possibility that there could be a conflict of interest at some point, or that it simply is a matter of having good interpersonal skills. In any case, we stopped after setting the stage for what the estate was, approximately how it had grown substantially, and how we have these 2 men in charge, and are in charge, in fact, today, currently. So let's now talk about the tensions that have developed between the beneficiaries and these 2 trustees. Now, we should also add the beneficiaries are 3 children, Paris, Prince, and Bigi, and that they all have complaints, though I think Paris has been the most vocal person. She did an interview in Variety magazine, I think. It's gotten a lot of attention. She's made some other public statements. She's filed complaints with the court. So it's really Paris, but I suspect that maybe the other 2 are not in disagreement, that they want maybe more money sooner, that they complain about the amount of the expenses that are being incurred in litigation as this case goes on. So there's dissatisfaction among the beneficiaries toward the trustees primarily. Oh, and let me hurry and introduce again Melanie McDonald, who's our senior litigator with Cordell & Cordell. She's in our Houston office. She has experience, of course. She's done a lot of domestic relations, but she also is working in our estate planning department. So she's unique in Cordell & Cordell. She and a few other attorneys where they're actually practicing in both areas. For the most part at Cordell & Cordell, we try to have people who do just estate planning and people who do just domestic relations. But we have some who are skilled in both. And so we thought, what a perfect combination of skills, incidentally, to talk about this. Often estate planning and domestic relations scenarios come together. Not so much at the end of Michael Jackson's life as before, but nonetheless, what are your comments about where I left off just now?
So thinking about the types of tension that can be created in this type of situation, what I'm looking at is that you have someone who is put in charge of somebody else's things, right? And the person who wants the things, they want what they want when they want it. And sometimes that's not always in line with what the person who has settled the trust had in mind. And sometimes it's not in line with what the trustee is allowed to do based on what the terms of that trust is. And so there's going to be constant conflict when they're saying, give me my stuff right now. I want more of my stuff, or you're wasting my stuff with all these other frivolities. And I need to know what's going on. And so I think that when you look at family tension that happens surrounding trust administration, it's par for course. It's going to happen, and it doesn't matter whether Uncle Joe's the trustee, whether there's a corporate trustee, or whether you have trusted, competent professionals as the trustee. The beneficiaries are going to say what they're going to say, which is, I want my stuff, and I want it now.
Yeah, and especially when it goes on a long time.
Yeah, when it goes on for a long time, and they're going to get impatient. They're like, okay, what are you doing? Because I think that, too, when they don't necessarily understand kind of the things we were talking about before on the purpose of a trust having the longevity that it has, they may be thinking more of the lines like, cash me out, give me my money right now, let me manage for myself. But again, that wasn't Michael Jackson's vision. Otherwise, he would have left it to you in a will and let you do with it what you will, liquidated the estate and wrote a check. But that wasn't his vision. And so he set it up differently because he wanted it to occur differently. And sometimes that's hard for the beneficiaries to understand.
Yeah, and that draws attention to a key purpose and responsibility of a trustee, and that's to fulfill the terms of the trust. Mm-hmm. It's true that the trust has to exist for beneficiaries, but it's even more true that the purpose of the trust has to govern. And sometimes there have been conflicts. There are some prominent cases where people have argued that the purpose stated in the trust did not serve the beneficiaries. That's kind of an esoteric sort of, appellate arguments that you sometimes see. Rarely does it come to that. Virtually always, the terms of the trust determine what are the benefits, and when they get them are the beneficiaries. And so if the trustee you selected is really loyal to your vision, and that's a key requirement in your selection of a trustee, are they loyal to your vision, or are they going to be susceptible to what the beneficiaries may want, which may be different, often is different from what the vision of the founder of the trustor, may have had. And I think that's part of the issue here is that these guys, I've not seen an allegation that they're doing something contrary to what Michael Jackson conceived. Have you read that anywhere?
No, I've not really seen that. I think that the crux of the argument with Paris particularly is more surrounded about whether or not the things that they're doing are necessary. Like, why are you doing this? Is this something that needs to be done for the estate? Why are you pursuing this project? Are you overspending on this project? Who's managing this project? And is that the best person for it? And are they wasting money because they don't know what they're doing? And so when you look at that as, okay, her critical concern is the management, the actual management of what's happening within the trust and whether or not the funds that are being expended in order to manage that trust are appropriate. So I think that that's kind of where the crux of her concern. And I think kind of like you said, the other two beneficiaries, I think at least the children, they're probably more aligned with her. I think Catherine may have some other ideas because she's a beneficiary also, but I think that her ideas may be a little bit different. And hers is more towards, why are you liquidating things in the estate? I think everything should stay in. And that's really what he told me that's what his goal was. And they are still bound by the trust document. That is what the trustee has to follow in terms of what the trustor's intent was when they settled the trust in the first place.
Yeah. And this scenario is so rich with ways to learn about how to create a better trust. And it's not always negative lessons, meaning lessons where they did it wrong at all. It really, the conflict itself brings to light some important issues and not necessarily mistakes that were made. And in this case, Michael Jackson, apparently his concept, because he chose these two people, was to keep these businesses going so that he can maximize the value of the estate. And that means that there's going to be decisions made in an environment where you have an operating enterprise being ran by the trustees to a great extent. They probably have people who are in charge of some of these individual things that report to the trustees. But still, the trustees are ultimately responsible. They're not going to, nor should they be expected to go and get approval for what even may be major decisions, but still are operating decisions regarding each of these individual enterprises and the decision to sell a piece of real estate. There's a context in which a trustee might be expected to inform and get the approval before doing it of the beneficiaries if, say, this were a family farm and that were the only asset in the estate. This is actually a case where it went to the Court of Appeals, and it was a family farm that had been in the business for a long time, but it wasn't making money. And the trustee felt, I need to move the money out of this into something that produces more money. But the children had gone and used that for years. And so this ends up being a litigation over a period of several years. It ends up in the Court of Appeals, and I think this was in New Jersey, where the court ultimately said that the trustees were wrong, that they should have gone to the beneficiaries, informed them about what was going on, and that this probably was contrary to the founder's intention because he wanted this family farm. He knew the family farm was important, and there were other indications, not expressed, but indications in his language or the language of the trust that was important to keep. It wasn't a clear violation, or it wouldn't have been an interesting discussion, and clearly the trustees would have been wrong. It was interesting because it wasn't stated specifically. So that scenario, contrast that with this. These are ongoing decisions about a huge enterprise. And for example, financing a movie, that's a big issue in this. Do you want to talk a little bit about this? Is it a biopic or?
Yeah, it was a biopic, and I think that the issue with Paris was that she felt as though the music producer did not have as much experience producing something of this nature, of doing movies, and there were multiple resets that had to be done, also multiple reshoots that had to be done, and she was concerned about the amount of money that was being spent for these things. And if he had more experience doing those things, that maybe some of those cost overruns would not have happened. One of the things that you described, especially when you're talking about the family farm, and we're comparing that to this type of situation right now, is that when you're looking at what the ultimate goal of the trustor was, when the language was written in the trust with the family farm, if we're silent on certain things and we're looking at the language surrounding the actions in order to interpret what the court is going to use to interpret what was the actual intent, what was the settler's intent in terms of what we were supposed to be doing, that helps us derive information for them to make a decision that, okay, well, the trustee was wrong in this situation because based on the language that there's a different course of action that should have been taken, and you should have gotten approval because of whatever the longevity or whatever the foresight was of the settler when they settled that trust. In this Michael Jackson case, I think that this is a little bit different, primarily because I think that if you're going to have a situation where you're seeking approval of the beneficiaries, you have to be clear on that. So when you talk about it's an opportunity for us to learn on how to create a better trust, and we look at these appeals court decisions, we pay attention to what happens in them primarily for that purpose. How do we write a better trust? So it becomes a term that now we know to make sure as we evaluate what it is that a client wants to do, what happens in that situation where an asset either needs to be sold or there needs to be something that's done that may be considered risky that the beneficiaries may complain about. Who gets to make the decision? We kind of do this in domestic when we have a tiebreaker regarding parenting decisions. It's the same type of situation. Yeah. What do we do? when we have this conflict between the beneficiary and the trustee in terms of that high risk decision. And so it's up to us as practitioners to come up with the language to make sure that when the appeals court reads this, right, that they know exactly where the settlor or the trustor was coming down in terms of what their intent was.
Yeah, and on this big issue, which really kind of triggered the most public blow up relating to conflict in this case between the trustees and the beneficiaries, this biopic, this movie that's being created, is apparently going to the costs are going to be north of $100 million.
Yeah, I think 150 million. Mm-hmm.
150 million. Wow. So, in defense of these trustees, apparently they both have been involved in producing movies before, and in fact, it was John Branca who had actually produced two successful productions in the past. I don't remember what they were, but his answer to the court was, "I have in the past been involved in these. I am an authority on this. I do know something about it." So yes, they did have to do some reshoots and whatnot, as you mentioned, but maybe, I mean, if you look at the I don't want to be devil's advocate here on behalf of just the trustees, but anybody who's read about the making of movies, I mean, the waste that takes place where they reshoot and they'll just ditch, scenes that they spent a ton of money on. I mean, it just seems to be the nature of this sort of investment where what we call waste is things where they get into it and they find they need to pull back out and do it differently. So I don't know that it tells of this, but I will say that this, I don't know, was it McLean or was it Branca Branca has stated that he felt that this investment was something that the time is right. And he gave an example of where the time was right in the 80s for something similar that blew up. Maybe it was the Thriller thing. He said the moment is right now. And he said it's the responsible thing to do for this business right now is to take advantage of this value and interest in Michael Jackson, and now is the moment. So he's insisting that he believes this is going to be hugely profitable. And it is a substantial part of the estate. I mean, whatever the valuation is, $700 million, whatever you want to call it. I mean, $150 million is a big bite. So we can understand the argument of the beneficiaries. Why are you risking our money this way? But I do think I come down on the side of the trustees here because I think this is probably consistent with the vision that Michael Jackson had. I mean, he chose two guys that the real value is to do something like this.
Exactly. And I agree with that 100%. And the reason is because and I think that the production with Cirque du Soleil was one of the productions.
Oh, that was one, yeah.
Yeah, that Branca had been involved with. But I believe that one of the things that you have to consider, and this is like no disregard and no disrespect to, any of the beneficiaries at all. But when you think about who has more experience producing these types of movies or doing this type of entertainment projects, and while I appreciate all of the children and mom, Paris and all of them, the thing is that who has more experience, the beneficiary that's wanting you not to take the risk, or the people who are actually taking the risk, who can actually assess and do the risk assessment necessary to determine whether this is profitable. And I think that in Michael Jackson's mind, he trusted Branca to be the person to make this decision, that him, along with his attorney, to make this decision on what to do with this biopic. Because personally, I think that the biopic, I mean, people have tried to do different types of, of demonstrations of his life. But I think that it is a huge opportunity, and one that if they hadn't acted when they acted, would that been an opportunity that was missed?
Yeah. Now, what would be interesting for lawyers is what if it turns out, despite it being a reasonable investment standing where we stand right now, I mean, before it takes place, and it turns out to be an utter failure. I mean, I feel these guys, I'm not going to feel sorry for them because they've made a ton of money off their job. But I'm sympathetic with the fact that they're going to take a whole lot of heat. But even if it fails, it's not proof that the beneficiaries were right. So it's a difficult role being a beneficiary. Think about who you thrust it on before you thrust it on them. And
Absolutely.
not that it'll be necessarily this complicated, obviously, but on a much smaller level, they'll make decisions depending on your estate. They may make some decisions that some of the beneficiaries may criticize, but you want them to do the thing, to live out your instructions in the trust in spirit as well as the letter. And I should also add that part of the conflict here, at least as expressed by Paris, is that it relates to communication. Now, this is probably maybe the most common complaint that beneficiaries have of trustees, more than anything else, really, I think, is the obligation to communicate, which by statute they have that obligation, and they can't be completely freed of the obligation, even if it were in the trust that the person who created the trust were to say you don't have to communicate with beneficiaries. Even that cannot override a duty that beneficiaries deserve to be informed periodically. But that standard is really met by once a year, unless there's something more specific in the trust or some urgent matter that comes up. And I just know that in the minds of these beneficiaries and beneficiaries in a similar situation where there's been delay and money is tied up for a long period of time and maybe there's investments they're not sure about, universally beneficiaries are going to want more communications then. But I'm not sure they'll ever get the level of communication that they want because it's just not realistic. Give me your thoughts.
Well, I think that in this situation, if you think about it, how even we handle communication with domestic, there is never too much communication. And I think that this is the easiest one to fix. One of the things that when you put in regular communication modes and methods, it may not necessarily be everything that's happened on a day-to-day basis where we're literally giving you a timeline. Well, I sent out a letter today. I sent an email and I made a phone call, and it's not something to that level of detail. But just a summary where they're able to feel comfortable with whatever the decisions are that you're making, that they're not being kept in the dark. So when you ask how much communication is going to be enough, I don't think for a beneficiary there's ever, because they're going to want to call you and ask you. And it doesn't matter, even in domestic practice, it doesn't matter how many times I send out a letter, I'm going to get a phone call or an email to ask me what I just sent you in that letter, in that email. Yeah. And so we have to be, I think, a little, if we want to avoid some of the conflict, and I don't think there's a way to totally avoid it. I think that there is a way to mitigate some of the impact of them feeling like I'm not getting any information, is to just create a communication structure that is regular, it's routine, and it provides them with basic information. If you're communicating once a year in a trust, that's difficult, because even though you're working on a really big project, and especially when we look at this from Michael Jackson level, we look at it from that level in terms of how much and how many projects they're working on and how many things there has to be an assistant somewhere in there who knows what's going on, that can shoot out an email or send out a letter.
Yeah.
And so the question becomes, who is the designated person to make sure that there is a liaison between the beneficiaries and the trustee, so that they never have that feeling that they're being kept in the dark. Because if I'm kept in the dark, well, that's when I'm hiring the lawyer to get my questions answered. So if we can eliminate that, they may not have 100% of the information, but how can we get them more? I think that it just becomes a situation where you're derelict of duty if you're not informing them anyway, because I'm pretty sure every state statute in every state and in the trust itself, there should have some term that talks about how often that communication happens. And if that says once a year in the trust, that doesn't mean it has to be once a year. You can make it more often if that's going to quell the concerns and the fears of the beneficiaries in terms of them wanting information and wanting to know what's going on.
And that ties in with our underlying purpose here, which is to make this information useful. And you just went to that, a key application, and that's that at the time that your trust is made, your lawyer, even an estate planning lawyer, ourselves excluded, even an estate planning lawyer might think that once a year presumption or default under the statute is enough time. And for some assets, it might be. But as you just pointed out, that we have the opportunity in drafting the trust to put in something more, to say once a quarter, to say that reasonable calls, or something that does have meaning in the law. Reasonableness does have a meaning in the law. But if you can be more precise, fine. But we want to be careful about struggling to be too precise. But still, your point is well taken, that this is a situation where it can be fixed. Now, in this case, I suspect that the language is kind of the standard language. Now, I'll say this too, for those of you who are thinking that what's to prevent trustees from just going off and doing their own thing, and you just have radio silence. It's not exactly that in any case. But at a minimum, they have to give you an annual accounting. And if you're what's called a qualified beneficiary, which means you're a clear beneficiary, not a contingent or remote, then you're entitled to get an accounting once a year, if not more often. And in this case, I would expect more often. So that means getting documents showing what has happened, what's been paid out, what has been retained, what major business decisions would have been made, like in financial statements to stockholders. Now, it won't be that detail, but it has to be sufficient detail for you to be reasonably informed as a beneficiary. And there's lots of law around this, and there's lots of penalties for trustees that don't do this. So I want people to know that it's not a black box, and you just wait to get a check or something. There is an obligation to inform. But again, when it's a complicated network of business transactions, as this scenario is, then that report may not seem that useful or detailed as far as your specific questions that you might have as a beneficiary. So there's still room for complaint by beneficiaries. But keep in mind that you can head off some of that by, when you're having your trust drafted, if your lawyer doesn't know to ask you specifically about these very things, how often do they report, what's their responsibility implied, then they go back to the default provisions, and the default provisions still guarantee you information and communication, but maybe not at the level you want. And we should mention also that what's kind of set this up, that I think has magnified this problem, is this case, the death occurred in 2009. So an estate was opened. And in order for the family, what's called the family trust, in order for the assets to be put into the family trust through what's called, some of you who watch this show, we use the phrase pour over will. It's a will that says, we want the bulk of the assets in my estate essentially to end up being transferred into this trust. So the trust becomes the beneficiary, essentially, a trust that already exists, or sometimes it's created in the will. But anyway, so we have this family trust that has these operating rules, and Michael Jackson wanted to get the money into that trust out of probate. And remember, probate is just the place that all this stuff lands if it's not already in the trust. I won't criticize the fact that this wasn't in the trust. There may have been good reasons for that. There are good reasons sometimes to not put something in a trust. Although I can't resist saying that if Michael Jackson had, in those bad years of his life when things weren't going well, if he had moved assets into the trust, he would have to pay either a gift tax or it would be regarded as a sale, meaning he creates this irrevocable trust. He moves the assets in there while he's alive, not in the estate, not in a will. He just does it like to another person, to this trust. And when you transfer it like that, then at that moment you trigger either gift taxes or it could be regarded as a sale. But either way, it can have money he has to pay at that time. But the reason people do that, if they have this suspicion at least that this asset is going to be worth a ton more in the future, is they're happy to pay those taxes because then they don't pay them again. So
right.
when he dies, when Michael Jackson died, it would have had no tax impact because this entity goes on. It's like he had transferred it to somebody, and then Jackson dies. Well, it doesn't impact the person who has the asset now, who owns it.
Right.
They go on living. Well, in this case, it's the trust. So I'm reluctant to criticize again. I mean, Michael Jackson had no idea his death was going to occur. He was young. His mother's age 95. My guess is Michael Jackson would have lived to be age 95. He was certainly, he looked like he was 20, in my opinion, when he died. So Michael Jackson, he didn't do that planning. That would have been nice. It would have wiped out what I'm about to tell you about right now. But anyway, so the assets were not in the trust already. And so he dies. They go into probate. And probate naturally would have been predicted it would take a couple of years under the best of circumstances when you have an estate like this. It's the best scenario. So during this period of time, the trustees are doing their job, plus market forces are having their effect. And it turns out that this value that, remember, the law says for tax purposes, the date of death, not a year later, not 10 years later. So this launched this incredible battle with the IRS. The feds regard this as a situation where they're owed like hundreds of millions of dollars, which they would be if the value of this estate were that on the date that Michael Jackson died. But he, at the date he died, I mean, it's pretty clear, even the feds finally, after a court of appeals ruled this way, after a federal court ruled this way, finally have had to accept that they cannot assign greater value to those on the theory that they were about to become worth a lot. So where they ended up is, I think that the trustees valued, for example, name, image, and likeness at $2,200 or something like that. And the Fed valued at, I don't know, $200 million. So this is how far apart they were. So it goes before the federal judge to hear on this particular issue, and there have been several issues that have been heard on, but this came up, and finally they got a ruling in 2020, a wonderful ruling. In other words, the judge really put his foot down, so to speak, his gavel down, and he said, look, the value is the date of death, and we're not going to go with some theory that because it appreciated later, that we're going to say that appreciation was somehow built into the asset at that time, and we have to assign it more value because we know what happened later. The judge just really slammed that argument. And so the feds immediately, this went from an argument over, I think their allegation was $400 million was owed. It may have been $700 million. Don't hold me, people, to this. But anyway, it was a whole lot of money the IRS was going after. So this whole estate has been sitting in probate, being argued over since 2009. And as we sit here today, it's still in probate and it's being argued over. Although now it looks much better. Now the argument is exactly how much is it. But the basis now is not this gulf that I was describing to you. Now it's much less. The feds have swallowed hard. Although, let me qualify that. They are appealing it. So that decision from 2020 or 2021 is being appealed, but that decision was solid, meaning it was perfectly what a law professor would say the law is. So anyway, so we have now the feds demanding money, but there's still disagreements over how much, but it's much less. We're not talking hundreds of millions now. I assume we're talking 10, 20, 30 million maybe. I don't know what the number is exactly. It's just, this was a huge win for them. And as long as the appellate court upholds it, which I think they will, then this is going to get settled. But through no fault of these trustees, incidentally, that this is still in probate. Maybe some criticisms over some of the other things we've talked about here, where beneficiaries disagree about communication. Maybe they didn't want Neverland. They didn't want Neverland sold. Some didn't. I think maybe it's more Catherine, his mother. And then, of course, I'm sure they disagreed with some of the other assets that were sold. I know that there were some complaints at that time. So, those things, yes. But as to this big picture issue where they can't have any assets distributed, even according to the plan of the trust, is because they can't get it into the trust. It's sitting in probate. So the question that probably should be coming to your mind right now is, so does this mean that they've not gotten any money in all this amount of time, 15 years, 16? And the answer is no. They do. It's called an allowance. They filed with the court to say, look, the family has expenses, and it's going to be some period of time. They didn't know how long it'd be, so they issued just an ongoing order that allowed allowances based upon lifestyle and other things. Well, it turns out, ironically, that Paris, did you read the portion that Paris has acclaimed what she's gotten versus the others so far? Paris, it turns out, has gotten $109 million since the beginning. And just this past year, she got, I think, much less, 2.2 million in 25. And that's much more than her two siblings have gotten. Now, I don't know the explanation for that. There may be something going on that justifies. So an allowance is something that the judge can approve to be paid out while a case is pending, where you can imagine, we don't think of these people as being dire because, they wealthy, affluent family because of his celebrity. But think of all the people we know who, if money was tied up that way. So the good news is during probate, when there's fights that go on for years notoriously, there are mechanisms to have money paid out that they know are very likely would be paid out anyway. So once they've identified the beneficiaries, they know what the terms of the distribution are, or they know the terms of the trust in this case, then really it's just a matter of they don't want to pay out more than if the feds had won, and then all of a sudden the money wouldn't be there. So you can see the problem in not paying it out is because they don't know how litigation's going to go. So there has been money paid out, much less than I'm sure they would otherwise have. But it's interesting that Paris has gotten far and away the largest portion. Now, where this goes from now, once this is resolved, and I do think there's light at the end of the tunnel here, then the money will be transferred into the family trust. Then it'll start being distributed according to the terms of the trust. So in a way, these two people we've named as trustees are really functioning as executors now, but they're doing that with an eye to the trust terms. So as an executor, they have to be sure that creditors are paid and those things we mentioned at the outset of the last show. So there are things that you have to do when you're either an executor or a trustee. They have some things in common. But in this case, these guys who are actually functioning right now are technically in the role of the executors. So, and you could argue of a trust in which it doesn't have many assets right now either because it's not been distributed from the estate. So I did find out, did you read where the terms of the trust apparently call for distributions at age 30 and 35 and 40, lump sums? That's not unusual. Would you talk about that, about provisions like that?
Absolutely. So typically what you have is a graduation of when these distributions occur. And there could be any number of reasons why, depending on who the beneficiary is and whether or not they have the capacity to handle the amount of money that they're going to come into at that point in time. So if you have a graduated schedule at 30, 35, 40, 45, typically the settler's intent is to make sure that there's a sustainability of the distribution. Because if we give you, say, $1 million when you turn 21, we want to know what 21-year-old is going to be able to manage that $1 million in a way that is going to have longevity, right? That they're going to be able, are they going to go and invest it? Are they actually going to go and do something that preserves that? So if the settler's intent is to provide for that child or for that person for an extended period of time, and they want to give these funds to them incrementally so that there's not waste, there's not an opportunity for them to run through whatever it is. And because if you get your distribution at 30, what you do with it is what you do with it. So if you alternately invest that and do other things with it and you have growth, that's better for you, of course. But sometimes you can't expect that the beneficiary is going to do that because, again, if they were going to be the prudent, responsible individual that you hoped that they're going to be, why would you need to go through this elaborate scheme in order to give them to give them the funds that they would receive as a beneficiary of the trust? So it is not uncommon, especially when they're children, and I don't like to say problem children because I don't ever think that there's a such thing as a problem child. I think that there are people who have complications with managing life circumstances, and that's the best way that I can put it. And for those folks that have complications with managing life circumstances, they need just a little more help in making sure that they're going to have benefits or funds in that distribution that lasts longer than the moment that they receive it. Because it's not unknown where someone who is very affluent, they live a certain lifestyle, they receive the funds, and they want to spend it on what they want to spend it on. And if I give it all to you up front and you waste it, then what's left? Where's the legacy? I put in all this work to preserve this for you, and what have you done with it? And I'm not even there to tell you about it. So what I would assume that Michael Jackson's intent was is I'm going to spread this out, because even though my children are going to have the ability to, through their own means, they're going to have the ability to earn and to generate income on their own, I want this to make sure that it is a good supplement to whatever lifestyle they're living at that moment. But I want it to be spread out to make sure that there is not waste, there is not an opportunity for them to squander and go through those funds rapidly. And this gives them longevity in terms of the care that they're able to receive based on those funds.
And it may not have called for all the funds to be distributed that way. I just know that there was reference in one of the court documents where there was the trust, once it gets it, it can go ahead and implement this. And I think they're probably already past 30 years old. I should know their ages. Do you know their age, Justin? Can you check their ages? So I guess they would get both payouts. If they're 35 now, they probably would get both of those payouts when this money goes into the trust. But I'm thinking that I'm hoping that the way Michael Jackson wrote that was that wasn't all of their interest. That some would
and I can imagine that there has to be some lump sum, and then there are other payments throughout. I mean, because depending on what it is. That where these kids are in their stage in life. And I say kids, but they're in their 30s. These are not kids. These are adults now. And what the hope is that they have the maturity. I'm hoping that my kids have the maturity
right.
at 30 years old to manage that, the little bit of money that my child is going to get. I hope that they have the maturity to do that. And so I think that that's kind of what Michael Jackson was thinking of when the graduated scale went in for those particular types of payments.
Yeah. So that's part of this impatience and conflict relates to the fact that there is a lot of money that is still captured and that these beneficiaries aren't getting access to the amount that they otherwise would if it were not in this process. But again, I think we've made clear this is not the trustee's fault.
Right.
This is an ugly battle with the feds. And I think that we shouldn't close without mention, when we talk about this conflict with trustees, there's been a lot of complaint, again, through Paris, but I think representing the beneficiaries generally, that the trustees have diminished the trust value by the fees and particularly attorney fees that have been charged, but I'm sure trustee fees. Trustees make money, and there's no one I don't think would deny the fact that they are entitled, particularly in a case like this, to a significant amount of money. There's not, under any statute that I know of in the country, fixed rates that will apply to all trustees. It's really based upon, what in fact, what was the intention, what's customary in the community. That's a big factor that's considered by judges in litigation over how much trustees are paid. They can't double dip. There's cases on that where if they're acting as a lawyer and they're also a trustee, there's language in it. I'll choose my words carefully. You can't simply assume that you get paid independently for both those roles. There has to be some benefit to the beneficiary. So it doesn't mean that you work for free as the lawyer, but it does mean that you can't simply stack on additional roles and then stack on without discount or consideration those respective percentages. So I won't even venture talking about what those percentages can be in your trust whenever you prepare it, but often it's based upon the value of the total trust. That's what you commonly see, and those are what I've seen tend to be lower single digits. But again, it would depend on the size and very much the nature of the trust. It's very much driven by the type of assets, and we could go on talking about how some assets would reasonably require what would end up being 15% of the assets of the trust, or even 20. I mean, there are those types of responsibilities that, because of your peculiar portfolio or whatnot, or the properties you own, so that I just want you to know that's very individual. So I don't know what these trustees are being paid. I'm sure that it's certainly made clear to the beneficiaries. They're entitled to know that. I don't know if their complaint is so much about that, but I shudder to think what attorney fees have run for this estate. All the litigation regarding even the issue with this movie. There were a few disputes there, and attorney fees that comes out of the estate. Even when you sue the trustees, if they have any sort of good faith defense, unless it's clear that they're wrong, they're going to pay for the litigation against you out of your money, the trust money, so to speak. So this is just, it's not a happy situation, but it only seems fair that if you're a trustee and you're wrongfully sued, that you should not pay for it out of your pocket when the beneficiaries do that, and that does happen, as you might imagine. So anyway, in this case, there is a complaint where I'm sure into six digits of millions, hundreds of millions of fees have been spent for lawyers here, and that's something that has caused friction. But I don't think that. We don't know that suggests there's anything wrong here, but it is creating problems. These people, in defense of the beneficiaries, they're watching while on the one hand, yes, their estate went up, wonderfully. But on the other hand, they're seeing that, $100 million, maybe more, is being spent in expenses. So they are frustrated, and you're going to direct that somewhat at the trustees. And I'm not saying that they're completely innocent of having made great decisions the whole way. I'm sure they made some decisions that probably they could have made better decisions along the way. But that's going to happen if you have a trustee and you put in the trust assets that are diverse and require a lot of active, skilled management. So let's go ahead and wrap it up here. Melanie, tell me what you would say in closing remarks.
Well, I think the most important thing to take away from this conversation is when you're planning for your estate, one, you're going to make sure that you have a competent estate planning professional to be able to discuss what all the options you have for the type of asset makeup that you have. And that's going to be different for every single generation, for every single age group, and every single status in life. So whether you own a house, you have children, or you own real estate, or you own other valuable assets, or you have name, image, and likeness, or any other type of intellectual property assets or things of that nature, it doesn't matter. Just making sure that you have a competent professional that's able to discuss with you what your options are and what your goals are. And also, when we're drafting, making sure that the attorney that is drafting offers you as many of the possibilities in terms of the things that we've discussed here. What do you do when there is a dispute between the trustee and the beneficiary? What are the responsibilities of the trustee in terms of communication? And one of the things that becomes really, really important when you're planning for yourself as the trustor, as the settlor of the trust, and you're going through these different scenarios of the what ifs and the what could possibly happen, that you're making sure that you have adequate solutions to try and avoid some of the conflict that we see here in the situation in the Michael Jackson estate. Some of the things are unavoidable. You're going to have beneficiaries that complain, especially in a situation where the probate of the state that you're in takes a lot longer. That's one of the problems with having a pour over into the trust. And I believe that you were alluding to that just a moment ago. But one of the things that we can do is make sure that it's complete. And in our consideration of what assets stay in and what assets stay out, that we're considering fully what the parameters are, what the implications are. Because if there are certain liquidity needs that you have and you need to keep certain assets, let's talk about the best way to transfer those or to move those as to not create consequences for the beneficiaries long term. So I think ultimately it's really a situation about having a trusted and competent professional on all sides, not only as your trustee, but also as the attorney that is working for you. And so hopefully those are the two things combined that will give you the best possible scenario. And also, it's not too soon to start doing this. It's very important to consider just in the span of your life. Of course, we're trying to have contingencies for all the different possible scenarios, but we can't read the future. We cannot, as much as I try and predict what's going to happen, I can only draft for the circumstances that I believe are probable. And that's what I can do. And so you want to make sure that you have a trust that is in place that can handle some of the possibilities that could happen, and that it's something that covers all the bases for you and the goals that you have for your trust.
Yes. And this is one of those situations where it's not good for the client for us to always expect the best when we're drafting those trusts in terms of what's going to happen. So
Right.
We do try to actually plan for the worst, and that best protects you because you're not around to protect yourself at that time in terms of your vision. Okay, with that, we will wrap it up. Thank you, Melanie. I think that this discussion's been a good one. I think it'll be of practical value, and we will, I'm sure, do this in the future. So till next time, this has been another episode of Life's Third Act. Take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.